All right, well, everyone, welcome. And yes, I'm David Kendall, and what you should know about me is I'm an entrepreneur who happens to practice law. So first and foremost, I think of myself as a business person, and my day job happens to be helping companies doing everything from formations all the way through financings, commercial agreements, employment matters, all the way through mergers and acquisitions, and everything in between. So for today, we're going to stay focused on the needs of the typical startup company or growth stage company. I would encourage all of you, to the extent that there's any material in particular that you want me to focus on, or if you have any questions, please feel free to hop in, because I'd like this to be as valuable as possible for each of you. And there's a lot of stuff that we could cover that's applicable to startup companies and growth stage companies. So to the extent that you can steer me towards where you're most interested, I would be happy to go. So I think that maybe what I'll start off with, which is typically a good place to be, are the formation and organizational matters for companies, and in particular, what I often refer to as founder agreements. So the agreements that those that are the initial startup entrepreneurs and the founders behind organizations, what they're looking at doing right from the outset. So one of the first things that you want to do in creating a company is, frankly, as the old adage says, to make sure everybody gets on the same page. And really and truly, there is some value in actually putting onto paper what everybody is planning to do, what everybody feels like they are committing to, and what they are expecting everybody else in the group to commit to. So, that is not necessarily even a formal document that I'm talking about. I think even before you go through any trouble of putting things onto a piece of paper and have something signed as a binding legal agreement, I think just getting an agreement on basic terms and making sure everybody has the same understanding is a very useful approach. And so the things that I'm thinking about that you want to be talking with your co-founders about are, all right, what is everyone's commitment going to be in terms of what assets, if any, they're going to put into the company? What is the time commitment that everybody is expecting to put in? And are there any particular things that are expected to be accomplished, right? So part of being successful is showing up, but typically for a successful business, there's more that needs to happen. So it's not just a matter of coming to work, but it's actually being productive and accomplishing the goals of the company. So when you're talking about what the commitments are, it can be as simple as, how many hours are people going to be putting in? Because it is quite likely that different people involved at the formation stage are going to have different requirements. There might be instances where somebody might be full-time and others might only be part-time. And making sure that everybody agrees and understands what that is the best way to make sure that people don't feel either that they're being taken advantage of or that somebody is slacking off. So the one thing that I'll advise everybody is that the thing that you can be sure of, if you don't actually communicate your expectation, then it's going to be hard for you to hold somebody accountable when they don't meet that expectation. So what is it that people are committing in terms of time, how many hours, and what is it they're going to do? What are their roles? What are their responsibilities? You might have one person that's in charge of moving forward the technology, building out a website or doing something of that fashion. There might be somebody else who's going to be in charge of setting up the business and the back office and the finance and accounting pieces. There might be somebody else who's expected to go out there and rustle up some initial capital, and or be somebody who's going to start generating revenue opportunities. And so making sure that everybody knows what they are responsible for and how much time they're expected to put in and what their goals are. What are they expected to accomplish? And that way you can measure people's performance based on what everybody agrees they're supposed to be doing. So that's a really good first step. Just that idea of who's in, what are they committing? And then the question becomes, and what does everybody get out of that? Although we are all equal in the eyes of the law, there is no doubt that some people have more skills, abilities, and ability to contribute than others. I always tell people that when I was young, I was very much anticipating being the shortstop for the New York Yankees as my career. Needless to say, that didn't work out, as Derek Jeter is about to be inducted into the Hall of Fame, because he had a lot more ability, skill, and aptitude in that job. And that's why he got paid a whole lot more money than I probably ever will in my career. And in part, you just have to be realistic among founders that just because you're all founders, just because you're all going to participate in a business, doesn't mean that you all bring the same amount of value. And it doesn't mean that you all deserve the same amount of compensation or the same amount of equity. And so often people think that the default and the starting point is going to be an even split in equity and compensation that's the same. I would say that I would recommend not assuming that is going to be the case, and actually make an affirmative decision. Does that make sense for what we're doing, or does it not? And by the way, Jennifer, I'm going to let you monitor the questions as they come in. And maybe if you will interrupt me as I'm talking, and anybody who wants to come off mute, I'm fine with that as well.
And just right before we get in, I just want to remind everybody that this is being recorded. But you do have a question. It says, do these expectations, commitments need to be explicitly stated somewhere?
Yeah, so I think that the best way to make sure that there are not misconceptions or misunderstandings is to ultimately get these things down on paper. And that's why I use that phrase of getting on the same page. Because even if we are communicating verbally and we're listening to each other, you'll be surprised, or maybe not surprised, as to how many times what one person believes they are saying is something different than what the recipient actually hears and understands. And one way to try and minimize that potential for miscommunication is to put it on paper. And so you've got two forms of communication, that oral communication as well as a writing. And yes, that way, the other thing is that we all have a tendency when we see something in writing, and then ultimately we're asked to go ahead and sign on the bottom line and agree to what might be in the writing, we all take it a little bit more seriously. And I think that's a good thing. And it's, I will say, I've done a whole lot of formations, but I've also done many business divorces. And oftentimes it's the lack of communication around commitments and what expectations are that wind up leading to instances where partners and co-founders stop getting along.
And when you say on paper, is that a legal document?
Absolutely. So, the funny thing is about legal documents is uh, they can even be on a napkin. If you write it, and you can write it in magic marker for all I care, but if you write it down and two people sign it, you have a binding contract. And so, yeah, I suggest, and in this world, of course, nowadays, it doesn't actually have to be physical paper. It can be an electronic document, and we can use electronic signatures. But the key is to have a writing in some form that ultimately everybody that you want to be committed and to agree to it goes ahead and indicates their agreement by an electronic or a physical signature. So yes, that's what I would recommend. So once you have that agreement on who's doing what and what you're getting in return, one of the things to think about is also, okay, who's going to make decisions? Who is the person who, and is it one person or is it a group of people that need to decide on how things will work? And so, we talked about coming up with an economic split and around compensation as well as equity that is not necessarily equal. The same is true of governance. Sometimes there are certain people that are either have the right experience or the natural ability to lead, and you want them to be the final arbiter, and you want that one particular person to be the person that's making day-to-day decisions. There's also an ability to group different kinds of decisions. So there may be sort of day-to-day operating decisions that one individual who's going to be say that the manager of the business on a day-to-day basis would make. But then you might say, but there's some issues that are so important that we want to make sure that everybody that's an owner gets to weigh in. For example, selling the company, taking on financing, so agreeing to borrow money, or acquiring another company. Those really big issues, sometimes you'll say we want every owner to have the ability to veto it, or you might say we want to make sure that 50% of the ownership gets to vote yes. But there may be things where you say, look, we're going to let one person be the CEO, and we're going to make them, we're going to let them make the decisions on day-to-day things, like what color paper to put in the copier, and whether or not to pick, a certain kind of laptop for everybody, or whether we manage our documents on a on-premises server or on the cloud. Those are the kinds of decisions that somebody can do, in an operational way. Let me quick look at the questions coming up.
Yes, there's two questions.
Yeah.
First one is something as loose as the number of hours someone can commit legally enforceable, especially since hours might fluctuate throughout the life cycle of a startup?
Yeah, and so I think that it is important to keep in mind that you'll have certain expectations, and there is going to be some amount of flexibility. And when you're coming up with these commitments, oftentimes it is smart to think about duration, right? Because what the company might need for the first 6 months may be different from what it will need in the following 18 months. And it may be something where, at the formation stage, all the founders agree to commit to a certain time period of doing certain things with the agreement that, every 6 months or every 12 months, we'll revisit and decide whether we have the right things. Do we have the right commitments? Do we have all that we need? Have circumstances changed so that we should change what the commitments are? And those things generally are enforceable. So, if you say that hey, people need to be in the office, 40 hours a week. Okay, then yeah, if they don't put in their 40 hours, then that's something that you could say you haven't lived up to your commitment. You're in breach. Of course, if we have something like we have today, and people can't physically be in the office, but they're logging their time from home and doing their work from home, that's going to be an immaterial difference. And so in the law, there's a question as to whether there's a material breach or an immaterial breach. And so, a minor deviation from what was expected is not usually a problem. And it's only if it's a material one that makes a difference. All right, I see Joshua is asking about a small venture. If you're by yourself, what benefit does organizing your business on paper provide? And when along the process would you move to form? And how do these situations change when you intend to work with freelance contract hires? So I would say that for many people, getting ideas down in some written form helps to organize and is a good self-check. So sometimes it's not just making sure that if you have a founder that you're each committing and you're holding each other accountable. Sometimes when you're on your own, you need to hold yourself accountable. And it is often helpful to have a written business plan, written goals, so that you can track. There's an adage in managing businesses that that which is measured happens. So if you set a goal and you're measuring progress towards a goal, generally it's more likely to occur. So when in the process would I form? So at the very early stages, even if it's only you in a business, to the extent that you start having any kind of interaction on a business standpoint with another party, be it a customer or an independent contractor or a vendor, that's when I would suggest getting into place some kind of legal entity. And the reason for that is that the various legal entities that are available in creating a company allow you in virtually every case, at least every case that folks like me would advise you to go towards, provides limited liability. And that limited liability means that what you have at stake in conducting your business is those assets that you contribute into that company, but your personal assets are not going to be at risk so long as you conduct your business as a separate entity and you honor the formalities of having a separate business. And so what does that mean? That means that you should have a separate bank account for your business as compared to your personal assets, so that you're accounting for and keeping track of monies that are coming into the business and expenses that are being paid by the business. And having that formation done, it means if something goes wrong in your business and somebody's damaged or somebody's injured, then they can go after the assets of the business, but they can't go after your personal assets. And just getting a very basic entity, a legal entity in place, can be done very cost effectively. I have taught business law before, and every single person in my business law class, within an hour, they knew how to create an entity, and they could do it on the Colorado Secretary of State website and could get it done for $50. So everybody can figure that one out. And then you had question about freelance or contract hires. Absolutely, one of the first things to think about when you're having others help your business, whether they are founders, employees, or independent contractors. One of the things to always keep in mind, most technology companies, one of the critical things for tech companies is their intellectual property. And you want to make sure that you put documents in place to have everybody that's involved with the company coming up with all these great ideas, that they all agree and commit that all of these ideas that they come up with will be owned by the company. Because, trust me, every person that is going to consider making an investment in a company, providing finance, or anybody that one time down in the future looks at acquiring a company, they're going to look very carefully at who helped develop technology and did they all sign something that indicated that they were freely giving to the company all of their great ideas. All right, some anonymous attendees. So are there different levels of governance that need to be documented? For example, decisions on what type of color paper to use in the printer versus hiring senior execs. Yeah, and that's a little bit of what I was referring to, that there's often different categories of just how important a decision is it. And so some of the things I mentioned as the really critically important things that you often want to have the actual owners weigh in on. Those are things like selling the company, liquidating the company, and bringing in new partners. So selling equity is something that is of that level. And depending, and we see this particularly in venture capital financing docs, you'll see a range in how many decisions and to what level the VCs have a chance to weigh in and veto certain things. In some VC deals, you'll see only kind of the 4, 5, or 6 really big ticket items that require their consent. But in others, you'll see 10 or 12 items, including hiring a C-level exec or firing a C-level exec sometimes. Another question about if there are 4 founders, is it possible to have one person own 100% and have the decisions, have one person own 100% of the decisions despite a 25-25-25 equity split? Absolutely. It's one of the things that I'll often say to our clients is that any kind of business deal that they can dream up and tell me about, I can figure out how to get it into legal documents. There are certain things where you have to play within the rules, and so as long as it's legal, and you give me the flexibility to figure out what kind of entity we need to use and what kind of equity, then divvying up governance and equity, pretty much anything you dream up can be done. So there are often times where there might be a situation where you would have a 25-25-25 and 25 equity split, but 3 of the 4, for example, might just be people providing money as a founder, and the one person is going to be the one that everybody is depending on to run the show, make the decisions, and make the company successful. And so it could be that 3 out of 4 people don't even have to show up for work, and it's all on that one person to make all the decisions. And so absolutely, that's something that can happen, and in the right circumstance, it should happen. All right, next one around, if LLC formation is so easy, is there any reason or are there certain circumstances where one should hire a lawyer for this? It's very similar to doing projects around your home. Sure, certain people, pretty much anybody, can swing a hammer and can probably operate a saw. But some people are more skilled than others. And so sometimes it depends on your experience. Certainly serial entrepreneurs who have been through the process before, they're going to be really comfortable with creating basic legal documents because they've seen them before, they've read them, they've had them explained, and so they're comfortable with them. And if you have a very simple business where it's only one or two or three founders that are involved, then as long as those three people agree and they're relatively aligned, then there's not as much risk about something going wrong. The place where there's more risk is when there are more people involved and where their involvement is different. And the more complicated the deal is, the harder it is to do it yourself. It's like the difference between hanging blinds in your bathroom and replacing the tub, the sink, and the toilet. My dad always used to say that he could fix anything in a house, and truly built his own house when he was a kid. He grew up in Newfoundland, Canada, where everybody had to be pretty self-sufficient. But he always said that he still, to this day, anything he does around his house, he will always call the plumber and always call the electrician, because that's where the biggest risks are. Patricio had a question about what are your recommendations for establishing a company whose value mostly comes from on a certain algorithm or technology. Yeah, so one of the questions that is often asked by founders at the early stages, what kind of company should I create? And so one thing to keep in mind is that the type of legal entity that you choose is often dependent on, one, what kind of company it is, and what path you intend to take with that company. And so some of the things to consider are what kind of financing do you think you will need? Is this a company that you believe is something that will eventually be venture capital backed? And will you need that kind of investment to grow it? Or is it a company that is going to be able to generate some of its own cash flow early on and finance itself? Certainly to the extent that you have visions of bringing in venture capital and growing a company in that style, then you will eventually need to be a C corporation. And in particular, most VCs force you to be a Delaware C corporation. LLCs and C corps and S corps that are formed in Colorado can easily be converted to C corps, and Delaware C corps. But if you know for sure that's the path that you're taking, sometimes it's easier to go directly to that and start out as a C corporation. If instead you have a company that is not going to need much outside investing, and remember, VC-backed companies sound sexy, and we see a lot of them that have great successes. But taking VC money comes with some trade-offs. You're likely to find that money a little bit more expensive because in part you're You're also getting value from the VCs in terms of experience and connections and ability to help grow the company. But in return, they expect to get a slightly better deal. But if you don't need that kind of assistance, and it's going to be a smaller company that's, maybe a services company that's going to do consulting, and it's mostly the people that are working there that are going to be involved and provide the financing, then it may be an LLC that has pass-through taxation, which means that the entity itself isn't going to pay taxes, but rather the income gets allocated to the owners. And that has only one layer of tax, which means for a cash flowing company, it'll be the most tax efficient. But if you're looking at a company that is going to need a lot of outside financing and is looking to one day, be acquired or be a public company, then there's opportunities to have other tax benefits like qualified small business stock exemptions, so that you can avoid capital gains in certain instances. And sometimes if you're heading in that direction, you're better off actually having two layers of taxation, because you don't expect to be generating income for most of the lifetime of the business. There's a lot of successful, it's funny to call it successful, but really successful technology companies that never, ever made income. They wound up being sold before they ever had any income. And yet the owners and founders did phenomenally well on the amount that they gained when they sold the stock. And the first time they ever had any kind of income or gain was when they sold the company. Grace. Grace, you're welcome for me being here. So looking at becoming a nonprofit. Okay, when speaking to other lawyers, they stress the importance of having a strong board of directors. Do you have any insights of things we should focus on when deciding on the composition of the board? Absolutely. So best practice for nonprofits, and I happen to serve on several nonprofits. I think at the moment I serve on 4 boards. So I'm all full up, but it's with every well-functioning nonprofit that I've ever been involved with, there's a plan that's put together in how to build out a board. And I've often heard that the things that a nonprofit needs is either people's time. And so if you need folks on the board to actually spend time to help with operations, that's one thing. Another is treasure. And so, that's simply somebody who can write large checks, which obviously can help go ahead and fulfill a nonprofit's mission and goals. And then it's also being able to be a transactional sort of person who can bring people together. So it's either folks that have certain skills and then put their time in. It's those that have connections that can bring the right partners and things towards the mission. And it's those that can write checks or have friends that can write checks. There are certain areas of expertise that are often really helpful. The folks that are often sought after to serve on boards are people who have finance and accounting backgrounds, because that's often something that nonprofit staff may not have background in. The law is something that's always nice to have somebody that's willing to do some advising on a pro bono basis or as a board member. And then I think it's subject matter expertise is always something that's important. So those are the other areas that I'd look for. But yeah, have a plan as to what skills and what contributions you need from your board, and try and make sure that as you grow your board, you're keeping an eye on all of those things. And it's not only for your current board, but also anticipate that you'll have board members that serve their time and then move on. And you want to be looking for who's going to replace the skills that you'll lose and the contributions that you might lose. All right, what are some common pitfalls for startups besides what you have already brought up? Yeah, so I think one of the common pitfalls, and I'll go back to a little bit of some of the things I've said, but around some commitments is, again, making sure that not only do you have people commit, but that you've got some sort of teeth behind the commitment, so that if somebody doesn't commit, that you want to make sure that there's a negative consequence for the individual who doesn't deliver, and or there's some kind of a remedy for the company itself. One of the things that I often warn founders about is when thinking about what terms you want to have for your your personal equity stake and things of that nature. Many of you, I'm sure, have heard about equity in startups often being subject to vesting, so that over time you earn the equity that you have, and that if you leave early, that what happens is the company gets to essentially claw back some of your equity. And often I hear founders say, well, I don't want that to happen to me, so I want all of our equity to be vested 100% upfront, because that would be the best for me. And the thing I always warn people is, if you're going into business with folks, and as much as they might be friends or people you trust, sometimes things change, or sometimes we misjudge. And you can always take care of making sure that you do what you have committed to do. What you can't do is make sure that others live up to their commitments. And so rather than worrying about how do I make sure I get to keep my equity, because that's easy. The way to do it is to go ahead and deliver on all of your commitments. The thing that I see people get upset about and regretting is when they don't have those commitments with remedies available vis-a-vis the other founders who wind up leaving. It's rarely there's as many issues with the people that stay. It's more often that I see people feel that they were wrong by founders who quit early, give up, and essentially let everybody down. So those are the things that I would in particular say that's where I see the pitfalls, is where people are looking about what I want for me, when instead they should be thinking about what is it that the company needs to be successful. And another thing that I'll throw out there is the importance of documenting things. When we're really busy and there's a lot going on, we forget to write things down, and we forget to dot our I's and cross our T's. And one of the most important things at the end of the day that we see, in the future, that winds up being the pitfall that comes up in the midst of a financing or in the midst of an acquisition is when there are loose ends that were left that weren't taken care of. So, for example, oftentimes if somebody agrees, you know what, I just can't do this. Turns out I've got an issue, with my family, a health emergency or something. So I'm going to leave early. I'm going to resign. And people say, okay, yeah, that's fine. And you'll agree that you'll give up your equity, right? Yeah, of course. Okay, good. And then nobody actually creates the document to make that happen. So those are the concerns. The promises that are made that aren't documented are the ones that wind up biting you at the end. Because another pitfall that I often see is that in the beginning, when everybody's getting along, and I always tell folks that you shouldn't go into business and found a company with people that you can't trust, that you couldn't trust their word, and I still want you to write it down and have everybody sign it, right? So yes, don't go into business with somebody that you can't trust implicitly, but just in case, write it down and have everybody sign, so that if at the end of the day somebody changes or life changes or something unexpected happens, that the company will be safe and the other founders are going to be appropriately treated. All right, so that's all of the current questions that I've had here. Thinking of the other pieces around startups that I often talk about, or that we promised we would put on this list here. I guess one idea that I didn't go into is around what happens when somebody does leave. What are their obligations after they leave the company? And so one of the things that often gets put into a founder agreement, and agreements whereby people are getting equity, and agreements where people are agreeing that the company owns the intellectual property that's created, so all the great inventions, all the technology, the algorithms, etc. We often say, okay, that we're agreeing is the company's property. We have people agree that they won't disclose it to anybody else. We also have them agree that they won't use it for their own benefit without the company's permission. And then moving further along those lines, we often will have founders and critical employees also agree to non-solicitation and non-compete provisions. So a non-solicitation is, in essence, that somebody won't try and steal customers or steal employees, so that they're not going to solicit those people to either go do business elsewhere or to go work for a competitor. And then on the non-compete basis, non-competes are a little bit harder to enforce because there's a public policy in every state to a varying degree towards making sure that people can make a living. Many of you have probably heard that one of the most expansive places around the public policy for people being able to make a living and not being restricted in the jobs they take is California. Colorado is more open to non-competes than California is. In California, it's virtually impossible to enforce a non-compete based solely on someone's employment. In Colorado, it is enforceable for people that are at a high enough level and at a sort of an executive or management level. And if they have critical information, secret information that would allow them to have an advantage and would be a detriment to the company if you allow them to immediately go across the street and start to compete. So non-solicits and non-competes are often included in a document that's called, often you'll hear the initials PIIA, and that stands for Proprietary Information and Invention Assignment Agreement. So the proprietary information is simply the confidentiality aspect. The invention assignment is this idea that I mentioned that any intellectual property that's created, any inventions, are going to be owned by the company. And then for high-level execs, we add non-solicits and non-competes to those agreements. All right, a question from Joshua. Is there a process for updating paperwork? Or is it as simple as these are the updated terms for X document agreed upon by X parties as of X date? Yeah, so again, both the great thing and the terrible thing about contracts is they are easy to create. And so you have to be careful about when you're actually creating an agreement, but they're also easy to amend. Most every written agreement will have an amendment section that specifically says how you can amend an agreement. And virtually every written agreement will say that this agreement can only be amended in writing. And that is generally true. Though there are some instances where if parties change their performance and do certain things, trust me, I took a whole semester class long on contract law where we talked about things like that. But yeah, for the most part, know that most written agreements can only be amended by writing. And at any time, no matter what the agreements are between any 2 or 3 parties, if all of those parties agree to do something different, so if they say, yeah, let's amend our deal, let's revise our deal, they absolutely can do it. And it's just a matter of writing it down and having everybody sign. All right, so we've got about 5 minutes left on our allotted time. I guess one other thing that's probably worth pointing out for everybody are some of the kinds of investment deals and sort of financing transactions that we often see for startup companies. Just so you are familiar with the terminology, many of you have heard of venture capital financing and have probably heard the terms Series A, Series B thrown around. And so historically, a Series A financing was generally the first outside round of investment that came from a sort of professional investor, so a sophisticated investor like a venture capitalist. Any investment that happened before that, it was often referred, if it was an equity investment, you'd probably hear of a friends and family round, which is exactly what it sounds like. It's more friends and family of the founders. And not those third-party institutional investors. And then in between, there was created this idea of the angel financing. So you had angel investors. And those were folks that were not necessarily your friends and family, but probably the wealthy guys that you came across in some function here or there, perhaps a rich uncle every now and then, that was a little bit more sophisticated than the typical friends and family, but wasn't to the level of being a everyday professional investor like a venture capitalist. So you might have heard of an angel round, which would be high net worth individuals that would invest in a company. There then came into being when Series A investors kept increasing the size of Series A financing rounds. It used to be that you could do a Series A round that was sometimes $2.5 million. Now you virtually never see a Series A that's less than 5 for sure, and it's rare even to see them less than 10 out in California or in New York. It's more likely in Colorado, but even in Colorado, the size of the Series A keeps getting bigger. And so people came up with a new term called Series Seed, and that's SEED for seed capital. For some reason, people thought that Series A should be considered bigger, and they needed to come up with a new name for something in the middle. And a Series Seed financing round is what I'll often refer to as like a Series A light. So the provisions are probably less investor friendly, little less onerous, and the documentation is a bit more streamlined than a typical Series A investment. But that's kind of the equity investments where you'll see friends and family, where they'll come in and invest alongside with the founders. Angel investors often will invest alongside, having the same kind of equity as the founders do. But it's for certain sophisticated angels, and once you hit a Series Seed, that's when you start having preferred equity. And so that's equity that has certain preferential rights in terms of return or in terms of governance rights and veto rights that have a special priority over the common stock that founders have. The other kinds of investments that you'll often see early on that are non-equity investments for companies are convertible financings. So often that's a bridge financing where a company is borrowing money, but the idea is that ultimately the convertible note that the investor gets will convert into equity in a Series Seed or a Series A financing down the road. And there's also something that was this sort of weird hybrid that was created called a SAFE. And SAFE is an acronym for Simple Agreement for Future Equity. And so instead of doing a convertible note that is then converted into equity later, somebody out in the Bay Area said, what if we just had investors agree to give money to a company and agree that eventually when the company does a financing round in the future, that the money that they're given today will be essentially put into the round that's done in the future at a discount and with some extra rights to make up for the time value of money in between when the SAFE commitment is made versus when the equity round is done. And so that gives you a quick sense of all of the typical ways by which money gets into a startup. The only other way which is one of the best ways ever to get any money into a startup. Often referred to as non-dilutive financings. In certain fields, there are opportunities where there are government grants that might be available to help fund a startup that is either creating technology, and it's often in the healthcare field, where there are government agencies that want to encourage folks to develop technology in energy and in healthcare that can be used for the public good. So occasionally you'll see that, and you just hope that you're, if you're lucky to get that kind of non-dilutive financing, that's a great outcome. So I think we're at our time. I hope I was able to cover most, all of the questions obviously that popped up, but I am here. I'm available to the extent that anybody has follow-up questions. As I said right at the outset, I'm an entrepreneur who happens to practice law, and we entrepreneurs have to stick together and look out for each other and help those that are coming along after. So feel free if you've got other questions, or if there's anything that I can do to be of help and support, I would be more than happy to do so. I was once, you know, in the same spot as many of you, and would be happy to help out. Just like once upon a time, there are folks ahead of me that gave me some helpful tips and pointed me in the right direction here and there, and helped me be successful.
Yes, thank you, David, for presenting today, and thank you everybody else for joining. If you guys did want to check it out again and watch this again, it will be uploaded on YouTube. And if you guys want to check out our other upcoming workshops, you could check projectxsite.org/xsitexplore. And if you have any more questions, you can email us at projectxsite@du.edu. But that's it. Thank you so much for being here.
Thanks, everyone.